Hi guys, welcome to Commercial Law Tutorials, Law of Lease. This is our first lesson. We are going to look at the definition, requirements and the characteristics of lease. In this lesson, we are going to look at the introduction, then the definition, requirements, and also the characteristics. In the law of lease, we deal with lease agreements or contracts and certain implied terms that govern these kinds of contracts. These lease agreements we are talking about can be either verbal or written. Verbal agreements are difficult to prove in case of dispute though, that arise on the lease terms set out between the landlord and the tenant. Hence, it is very important to usually have the lease agreement written down. What is the law of lease? A lease agreement is entered into when a person gives use and enjoyment of his property to another, who is the tenant, for a specific period of time in return for payment of rent or a lump sum payment called premium. So one person with the landlord gives another person his property, the tenant, so that the tenant can use and enjoy the property of the landlord for a specific period of time they would have agreed, while the tenant will be paying rent to the landlord for the use of that property. The tenant will be given possession of property under lease by the landlord, and the tenant will use the property, enjoy and benefit from the property for an agreed period of time while paying the landlord a certain amount of money, as we were saying, for the use of the property in the manner that they agreed. Therefore, a lease transfer right to the possession of a property belonging to the landlord to the tenant. The tenant will be having exclusive possession of the property and not ownership though. The landlord keeps ownership of the leased property and transfer possession only. The ownership of the property under lease cannot be transferred to the tenant except by alienation, using either contract of sale or as a gift. Depending on the terms that are written or agreed between the tenant and the landlord, the tenant may have also the right to transfer that right of possession that he has to another person, a subtenant, through sublease. That is what the law of lease is all about. Let us look at the essentials of a lease. In the case of Street versus Montford, the essential elements which make up a lease agreement were stated as exclusive possession of property, rent, and certain term that is agreed between the landlord and the tenant. So that case gives us the essentials of a lease, which are the parties, the subject matter of lease, the duration of lease, and consideration, which is also called rent. The two parties in the agreement should be identifiable, that is the landlord and the tenant. There should be two parties in the agreement. There must be the subject matter of the lease also, that is the other essential. There must be the thing or property which is under lease. For instance, a house, land, and this may include the benefits which arise out of the land. Therefore, for there to be a lease contract, there should be exclusive possession of property under lease. One should be able to use the property as a tenant and also may have the right also to gather and enjoy the civil and natural fruits of that property. Duration of lease is the other essential. The right to enjoy the property must be transferred for a certain period of time or in perpetuity, with an exact date of commencement of the lease agreement. That is when it is called a lease. The last essential is rent. Rent is what the landlord benefits from giving another his property. Its amount should be stated as well as the time period or frequency landlord expects payment, for instance weekly, monthly or yearly. Rent can be in form of money or in form of any valuable thing. For instance, on a farm, the output on that farm can be used by the tenant as rent, which he paid to the landlord after a certain period of time, for instance maize. Let us look at characteristics of a lease. What are the characteristics of a lease? There is certainty of parties. The parties to a lease should have the capacity to enter into a lease contract. The owner of the property or his agent, who is authorized by the landlord, should lease the property, not anyone else who doesn't own that property. So the parties should be certain. They should be the landlord and tenant. Then certainty of property. The property should be identifiable and ascertainable. Location also should be stated. There should be a certain commencement date. That is the date the tenant will assume occupation of the property. Date can be either specific or upon occurrence of a specific event or circumstance. So it can be specific or upon occurrence of a specific event or circumstance that the tenant and the landlord agreed on. There should also be certainty of term of lease. Then there should be payment of rent. That is the other characteristic. Rent should be paid by the tenant as consideration for the use and the occupation of the property. And as we have already said, rent can be in form of money or any valuable consideration. There should be exclusive possession. The tenant has the right to exclude others from the property, including the landlord himself and his authorized agents, until expiration or termination of lease. And lastly, the landlord has the right to get back the property from the tenant after the expiration or termination of lease. Those are the characteristics of a lease contract. Thank you so much for watching. That was all I had for you today. Remember to subscribe and like if you haven't done so.